To learn a lot.
My audience would not forgive me if I did not bring this question to your attention. One of the major issues, and our U.S. Attorney is well aware of it, one of the major issues in this community, and it started on when we started this program 8 years ago, were people that brought to this program's attention the problem of the pervasive use of background checks, screening people out of employment because of past offenses, past felonies. We've had not only people who call up and say they're denied employment because of a felony that's 15 years old and that person has been out 14 years and had a clean record, but that felony still, is causing denial. We've heard of people who actually went through an employment process, told the truth in the employment process that they were an ex-felon, were hired in the employment process, but the background check took a while to be done. And after they were hired on the payroll, then the company comes back and says, oh, we got the background check, you're fired. And it's like, how in the world is that legal? Those things. We've had people who've lost jobs because of an arrest that was never a conviction. First of all, is this something you and your division have heard in other parts of the country? Because it's almost like it's a big issue here and we can't understand why it's not a big issue across this country.
We've had conversations on this issue, Amos, with the Equal Employment Opportunity Commission. That's another federal agency that investigates allegations of discrimination in the workplace involving private employers. The bulk of discrimination allegations in the United States go to the EEOC.
Right.
We handle public sector employers, police, fire, corrections, but the bulk of cases go to the EEOC. We've had a conversation, and we have an ongoing conversation with the EEOC, who, along with us, has heard this quite a bit. And the question presented is it, at least from the civil rights perspective, would it be a violation of Title VII of the Civil Rights Act? And so it's a very fact-intensive determination about whether a particular set of rules is having a discriminatory impact on a particular race or ethnicity. And so that's the question that is being asked. And it's a question that's being asked not simply here in Indianapolis, but it has been asked elsewhere.
You're well aware that because of cable television and the 24-hour news cycle and the internet, people everywhere see alleged cases of police brutality, of violations of color of law. To the extent that you can, and I know you're an officer of the court, you're an officer of the United States of America, in the Brandon Johnson case, why was that not a civil rights deprivation in the eyes of the Justice Department?
Well, the question that we were asking, Amos, was whether it was a criminal civil rights deprivation, and that's an important distinction. In the federal system, we deal with one law. Sometimes in the state, in a number of states across the country, you might have 4, 5, 6 different laws that you use to deal with police misconduct. So you might have premeditated assaults, you might have criminally negligent assaults, etc. And so the level of proof required is different. In the federal system, we have one statute. That's it's one and only one. And the statute requires us to prove the highest level of intent possible. So we have to demonstrate beyond a reasonable doubt to 12 jurors that the officer involved specifically intended to violate the constitutional rights of the victim. So we have to demonstrate that they knew what they were doing violated the Constitution, and they did it anyway. It's the highest level possible.
So it's premeditation, in essence.
Well, yes, it's specific intent. So you knew what you were doing was wrong, and you did it anyway. And again, and we said this to we met with the victim. We met with his attorney.
Right.
The people from my office and Joe. We had many conversations, and you were very, very helpful at this time. And again, I want to be specific in saying we found that there was insufficient evidence to establish the criminal civil rights violation in this particular case. Does that mean that his civil rights were not violated? No, it means that we made a determination that we could not prove a criminal case beyond a reasonable doubt.
And then obviously you all, because you're the government, don't do civil cases.
Correct.
That has to be handled by the family.
That is correct. And
Okay.
so obviously they can, they have the right to file a private civil suit in which the burden of proof would be lower. And so we are not offering an opinion in making our judgment about whether or not the civil rights of Mr. Johnson were violated. What we are saying is that given the hand that Congress dealt us in this case, we
Okay.
could not establish that very heavy burden of proof.
He's got time to take a few questions because he wants to listen to the community. 239-13.